pleas and attorneys. So, irregardless of the reasonable and objective things you may have in front of you, the stress and other factors that's been going on in your personal life, what cause you to put common sense to the side and, they would stick that British accreditation register number on you. They will do it. It's a general mode of operation because the alleged public court system is a venue to recruit customers, clientele, and they run it and make money off of it. So everyone is at a different level of development, and whatever level of development you're in, we're all growing. What you're comfortable with, regardless of the objective factors involved in everything that's going on. You might go, okay, all right, I know I can present my own contract to this attorney. They really want to assist me. I know they provide legal service that I cannot be compelled to based on the right of association, but I just want to get rid of this thing. I just want to get it over with. Even if it's probation, all that, let me just get rid of it. The best thing an attorney will do for you, and the script of an attorney, is to get you to plead. It will get you a plea deal. Whether that plea deal constitutes you spending some time in prison, jail, halfway out, or you being in jail outside, which is probation and supervision. You have to meet up during this time and during this day and on a certain consistency, once, twice, 3 times every month, and they limit your substantive rights. You can't move out of the state without permission. You can't move out of the city. You have to tell us before you do this and do that. You enter into that contract with them. So you're saying, you know what, I'm just going to plead. All right. I say, cool. Go ahead. Do it. Yes. Do it. But before you do it, consider this basic factor. A plea is the answer required by law. That law is based on the rules of evidence that is constitutional. And that law, believe it or not, is just your right and obligations to enter into contract. It's that simple. It's your choice to make a determination about one thing or the other. Do they know that you're a minor? Do they know that you're under duress? And they're given the fact that you're a minor and you're under duress, you really can't enter into certain contracts? Yes, they do. But the contract favors them. So why would they give you disclosure of this? So you can always attack pleas on that end also. And sometimes if you read their papers, they'll let you know that this plea can be withdrawn. And some states' rules of evidence let you know that the plea can be withdrawn. Some states let you know, well, even if it's withdrawn, you're still going to have to prove certain things. And in some cases, the attorney will sign on your behalf, since an attorney is, pushing it on you. So if you really plan on, if you're under duress at the moment and you really plan on fixing your issues later in the future by appeal one way or the other, don't sign that appeal. Have that attorney sign it in their name. You don't put your hands on it. That's your way out, because you can challenge the validity of that plea just like that. But that's a whole nother thing with appeal. But the answer required by law, the right to contract, of one formally accused of a crime. This is a very simple definition. You don't even have to go too far to see what is right and what is wrong. And it gives you a reference. If you have any American jurisprudence books, you can look at the details of all the adjudication and case laws that pretty much explains the summary that's here. And that is that you have created a contract, that you have formally been accused of a crime. And a plea deal is usually offered to you at the beginning of any case. So what you're effectively doing is you are waiving any right. You like to talk about your rights, right? You like to say you have rights. We all do. But the moment you enter into a plea deal, this is the extremely important part. You waived your right to due process, which constitute your right to be heard, your right to a jury trial. That is very important. The moment you enter into a plea, you have waived the right to trial. The moment you enter into a plea, you waive the right to try the sufficiency of the claim that is being brought against you. You might think you pleaded not guilty, so I'm off. No. You pled without testing the sufficiency of it. Just because you say that you're not guilty doesn't mean it's been proven. The presumption is still against you because the charges are there. Unless the case has been dismissed, then you are still presumed to be guilty. Yes, the presumption of innocence ought to exist in common law in North America. But you're pleading, so you waived all those rights, those constitutional secured rights. It's telling you the answer required by law of one formally accused. The moment you plead, you are accepting that that is a form of accusation that you have accepted. And you have waived all the rights that you have. The moment you plead and you try to come back and start talking about right this, rights that, they're just going to roll their eyes and just let you do what you want to do. And then they do what they want to do. This is not to discourage you. This is to show you the reality of what is going on. Then it goes on to say the pleadings by way of answer to a petition, aka the charges they brought against you, declaration, the charges they brought against you, the police report, or complaints, the charges they brought against you. In equity, by the way, law and equity are separate jurisdictions of their own. In equity, a special answer to all or some part of the bill. Bill is, in equity, is just another word for complaint or declaration or petition. So equity has its own terminology separate from law. But on a single issue, setting up in lieu, aka in place of, a detailed reply to all allegation. Ding, 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 right there. A plea is a supplication, a substitute, a replacement for any detailed reply to all allegations. Meaning you waive your right to invoke all the different affirmative defense, your ability to put your truth in, your ability to bring witnesses. You cannot cross-examine or direct examine any witness. You cannot do interrogatories. You cannot do discoveries. You cannot do a writ of reprimand. You cannot do a constitutional challenge. You cannot do shit. You waive it whenever you plead. Don't think pleading helps you. Pleading, when you plead guilty or non-guilty, even though sometimes in the rules of procedure, your documents that you put in are considered pleadings, but when it comes to plea deals like guilty or non-guilty, do you plead guilty or non-guilty? This is what we're talking about here. Because the moment that you plead, you've won. Even if you did nothing wrong, you're saying, yes, I did everything wrong and I waive everything. So do with me as you wish. Some particular fact or facts as a cause for dismissing, delaying, or barring the suit as a whole. You know, they're not going to dismiss, delay, or bar the complaint or the bill. They're going to do the opposite. Bottom line, plea deals might be brought to you and will be brought to you under duress, will be brought to you through hypnosis. Plea deals will be one of the first things that's going to be thrown on you, either by the acting judge or by the other British accreditation registry member called the attorney, public defender, state attorney. So think twice before you plead. As good as it may sound, as good as it may sound from the other party, as good as it may sound in your mind, because you're thinking you're evading liability, what you're really doing is you're dipping yourself deeper and quicker into that quicksand. When you're in the quicksand, you need to be smart and you need to be methodical. Someone is telling you, just jump up and down and you'll get out, and you're doing it. Oh, my friend, you're going to go deeper into that sand and you're going to be doomed. Don't do that. Be smart, be wise. Don't plead. But if you want to, that's fine. But just put these basic principles into consideration. And when you do this right here, guilty or non-guilty, you waive all of this. You waive your right to not incriminate yourself. Just pleading, please, is a form of self-confession. And now you cannot, when you appeal, you cannot say, well, I didn't do that. Well, yes, you did. That's why I said don't sign it. If an attorney really wants to work for you and they don't want to sign a contract with you, just have them sign it. Don't have them sign your name, but have them sign it in their name. Now put the trust in them. Create that trust verbally. Then, play dumb along with it. Exercise that constitutionally secured right by law to enter into contract, because you're free and independent to do so, and it is your inherent and inalienable right. You cannot be deprived of life, liberty, and pursuit of happiness without due process. Create your own due process if you're being limited. If you know that you're in a tight situation, the circumstances are infinite in nature, so I cannot just limit it. But whatever your situation is, if you think plea is what you have to do, even though it's not smart at all, you should not even do that at all. But if you think that's what you have to do, okay, just don't put your hands on it. Get that attorney to sign it. That way, you can use that as grounds for appeal. But nonetheless, bottom line, don't plea. Because plea is a replacement to your affirmative defense in a constitutionally secured right. And you are doing a self-admission that you've been accused of a crime. Whether it's not guilty or guilty. And really, it is just that simple. Best of luck.